Chapter 5. Subrogation among parties to bills and notes. 181. An endorser upon payment subrogated to rights of holder against prior parties. The payment of a note or bill by an endorser to the holder thereof will not extinguish the instrument, but the endorser, after his payment, whether made voluntarily or upon compulsion, if he was liable for it, will be subrogated to all the remedies that are available upon the note or bill against the antecedent parties thereto, including the right of action against a bank which has by its negligence caused the release of a prior endorser. A partial payment by an endorser will not extinguish pro tanto the liability of antecedent parties unless it was made in their behalf, and not by reason of the liability of the party making the payment to the holder. The holder of the note can still collect the full amount thereof from the parties who are antecedently liable thereon, receiving the amount of such partial payment as a trustee for the endorser who originally made it, unless the ultimate liability to pay the note rests upon this endorser as between himself and the other parties to the note, in which case the payment made by him will accrue to their benefit. So the holder of a note, after receiving payment thereof from the endorser, may maintain an action thereon at the request and for the benefit of the endorser against the maker, and the latter cannot set up the endorser's payment as a defense to the action against himself. The endorser of a promissory note, after its maturity and after high liability upon it has become fixed, does not cease to be entitled to the rights of a surety and become a joint principal debtor by joining with the maker of the note in a bond giving further time for its payment, although the bond does not describe him as a surety. It has been held that the joint endorsers of commercial paper, though liable as co-promisors, have upon payment no right of subrogation against each other. But it is now usually considered that the true relation of all the successive parties to a note or bill to each other may be shown by parole evidence, and that their rights of subrogation will depend upon their true relations as thus established. 182. Be maker of a note not entitled to the benefit of payment made by endorsers thereon. The maker of a note is prima facie the party ultimately liable thereon, and is not entitled, in an action on the note against himself, to a deduction for a partial payment not made by him or in his behalf, but by an endorser or by a guarantor, for such a payment does not in law inure to his benefit. An endorser, upon taking up a bill which he has endorsed, is entitled like a surety to receive securities which the holder has received from prior parties to the bill, the debts secured by such securities being first fully paid to the holder, and he is entitled to the benefit of a proof previously made by the holder of the note against the bankrupt estate of the maker. The holder of a note is entitled to prove it in full against the bankrupt estate of the maker, although he has since the bankruptcy received a partial payment thereon from an endorser on the note. The general rule undoubtedly is, said Lowell J., that the holder of a note may prove against all parties for the full amount, and receive dividends from all until he has obtained the whole of his debt with interest. It is likewise the general rule that what he has received from one party or from dividends in bankruptcy of one party to the note are payments which he must give credit for if he afterwards proves against others. I am of opinion that this latter rule must be confined to cases in which the payment has been made by the person primarily liable on the note or bill. The better opinion at common law is that payment by a drawer or endorser does not exonerate the acceptor or maker, unless the promise of the latter was for the accommodation of the former, or there is some other equity which makes the note or bill the debt of the party who has made the payment, or unless he has made it at the request or for the benefit of the acceptor or maker. If this be not the rule at law, still I consider it to be so in bankruptcy. A creditor may prove the debt, notwithstanding payment in whole or in part by a surety, because he in fact proves as trustee for the surety. On the other hand, a partial payment of a bill by any party to it inures to the benefit, and is a discharge pro tanto of the liability of all subsequent parties. Consequently, any payment or dividend received by the holder from a prior party before proof in bankruptcy against a subsequent party must be deducted from the amount of the claim provable against the latter. 182a. Endorser or accommodation maker of note regarded as surety merely. An endorser of a note or bill, or one who has to the knowledge of the holder thereof become a party thereto merely for the accommodation of the maker or primary debtor thereon, is to be regarded merely as a surety of the primary debtor, and has all the rights of a surety. But parties who have exchanged notes with each other cannot claim to be accommodation makers or to have the rights of sureties. The endorser's right of subrogation will not accrue until he has paid the note, but it has been held that an endorser of notes secured by a deed of trust who has been compelled to pay the interest thereon acquires by his payment an interest in the security which is complete against the debtor and awaits only the full satisfaction of the creditor to become complete as against all parties, so that upon a subsequent foreclosure by the creditor, the endorser may have a decree for the interest so paid against the original debtor. One who makes a promissory note for the accommodation of another has the same rights against the holder of the note who has notice of the facts as any surety for the debt. Such a surety has the same right to be subrogated to the benefit of any collateral security held by the creditor or holder of the note, and the same equitable right to be discharged by the creditor's surrender of any collateral security or impairment of the right of recourse against the principal debtor as would be possessed by a surety eo nomine, though this has been denied in 2 old cases. Thus, if a mortgagee, when one installment of the mortgage debt has become payable, so conducts himself as to operate a release of the mortgage, this will release the endorsers of notes which had been given for subsequent installments of the mortgage debt. But as would be the cue with any surety, if the endorser has himself assumed the burden of the debt as his own, then, as he would not be entitled to take the security by subrogation, he cannot complain of its release by the creditor. And the right of an accommodation maker to demand the privileges of a surety against the holder depends upon the holder's knowledge of the relations between the parties to the note. The apparent principal has not the rights of a surety against the creditor unless the real facts were known to the creditor. So an accommodation endorser, on taking up the bill, may hold an accommodation acceptor, but not a subsequent endorser. 183. Transferee of bona fide holder substituted to his rights, though himself chargeable with equities. One who takes a bill or note from a bona fide holder for value thereof will be substituted to all the rights of such holder, although he himself takes it overdue or with notice of facts which would otherwise constitute a defense to the note or bill in his hands, on the ground that the purchaser is subrogated to all the rights of his vendor. So the endorsee of protested drafts on which a direct action was prohibited by statute has been subrogated in New York to his endorser's right of action for the consideration paid for such drafts. And the same rule has been applied to a void certificate of indebtedness. But an endorser is not always by his payment subrogated to all the rights of the holder from whom, upon his payment, he takes the note against prior parties thereto. If the notice of dishonor sent by the holder to the first endorser was wrongly addressed in consequence of erroneous information carelessly given by the second endorser to the holder, though the latter, having used due diligence, might have held the first endorser to pay the note, yet the second endorser, upon taking up the note from the holder, cannot do so. For it was his fault that the notice was not properly sent. The principle that a notice given by the holder will inure to the benefit of the other parties to a bill or note does not apply to such a case. 184. Acceptor of bill supra protest substituted to rights of holder from whom he takes it. The acceptor of a bill supra protest for the honor of a particular party to the bill succeeds to the rights of the party from whom he takes it, except that he discharges all the parties to the bill subsequent to the one for whose honor he takes it up, and that he cannot endorse it over. Accordingly, he can recover on the bill against any prior parties thereto who could have been held by the person from whom he receives it, or by any prior holder of the bill, even though they could not have been held by the one for whose honor such acceptor has taken up the bill. As the acceptor supra protest is liable like an endorser, so when he takes up the bill upon such an acceptance, he is entitled to hold antecedent parties as an endorser could do. 185. Transferee of notes of bills entitled to the benefit of security held for their payment. The right to enforce security given for the payment of a note will pass to the endorsees or transferees of the note, even though the security itself has not been formally transferred or delivered to them. A. Mortgagee's endorsement and delivery of the notes secured by the mortgage will operate as an equitable assignment of the mortgage itself. The holder of the legal title to the security will be considered to hold it as a trustee for the benefit of the endorsees. When the purchaser of a melodeon gave his note for the price thereof, with the agreement that the property should not vest in him until his payment of the note, it was held that the vendor's interest in the melodeon was merely an incident to the note, as in the case of a mortgage or pledge, and that it passed to one to whom they endorsed the note, so that trover for the melodeon could not afterwards be maintained in the name of the vendors. And after a bona fide transfer of the note, not overdue, and for value, the holder of the security cannot discharge it to the prejudice of the holder of the note. Such a taker of the note may enforce the security in the hands of the payee of the note, even though this payee could not himself have enforced the security against the maker of the note by reason of the equities between them, although this has sometimes been denied in the queue of a mortgage. But one who takes the note overdue will not be protected by this principle against such equities of the owner of the security. The equitable lien of a vendor of land to secure the payment of a note which be as taken for the purchase money will not usually pass to an endorsee who cannot hold the vendor for the payment of the note, since the effect of the transfer was to secure to the vendor all the advantages of a payment. Nor will the mortgagees bear right of action for a mere tort pass by his transfer of the mortgage note. 186. Rights of a stranger upon taking up a note. When at or after the maturity of a promissory note, one who is not interested in its payment, either as endorser or as surety, takes it up, declining to have it cancelled, but saying nothing about buying it, and not stipulating for a conventional subrogation to the rights of the holder, he is not subrogated to those rights. But the note is paid and satisfied, and the indebtedness of the maker is extinguished. The voluntary payment of the note made by one who is not bound for it, and had no interest in discharging it, affords no ground for subrogation. But if a stranger has made such a payment without a previous authority from the debtor, and before any ratification of the payment by the debtor, the creditor and the stranger undo the transaction, and the creditor returns the money to the stranger, it is then too late for the debtor to ratify the payment, and the creditor can enforce the original obligation against him. Such a payment made by a stranger becomes an efficacious payment only when it is ratified or adopted by the debtor, although such ratification and adoption may be made and shown by the debtors setting up the payment as a defense in an action against him on the note. A third person who has given to the holder of a note his written agreement to be holden for its payment like an endorser will neither be regarded as a mere stranger nor yet as a party to the note. And if he pays the note upon the default of the parties to it, he is entitled to the note undischarged, and may maintain an action thereon for his reimbursement. And if a stranger takes up a note, this will be deemed a purchase, and not an extinguishment thereof, if such was the intent of the parties. 187. Holder of note substituted to benefit of security, given by one to another party to the note to secure its payment. Property mortgage to secure to the mortgagee. The payment of notes endorsed by the mortgagee for the benefit of the mortgager will be applied in equity, upon the insolvency of both maker and endorser, to the payment of such notes, and may be so appropriated by the creditor upon the insolvency of only the maker. And such a mortgage, not being when merely for the indemnity of the mortgagee, cannot be released by him so as to deprive the holders of the notes of their rights under the mortgage. And notes issued by the mortgagee to the mortgager in consideration of the mortgage, and purporting on their face to be secured by the mortgage, will be protected by the mortgage in the hands of third persons to whom they have been negotiated for value, even after a discharge of the mortgage by the nominal mortgagee. But security given by one party to a note to another on a secret trust for the payment of the note will pass free of all equities to a bona fide purchaser for value. 188. Substitution of the holder to the benefit of indemnity held by an endorser. Given by the maker of a note to his accommodation endorser thereon, to indemnify the latter against his liability, is not an accessory to the principal obligation, but merely a personal indemnity ordinarily available only upon payment by the endorser. Such an indemnity would not be available to a surety upon the note who had been compelled to pay it. For the maker, though a surety, and an accommodation endorser are not co-sureties. nor has an accommodation maker the rights of a co-surety against an accommodation endorser, nor have successive accommodation endorsers the rights of co-sureties against each other, unless they have agreed to become such as among themselves. The holder of the note cannot in equity be substituted to the benefit of the endorser's indemnity when he has obtained no judgment against either maker or endorser, and does not aver that either is insolvent or that the debt cannot be collected on execution. If the endorser has been discharged from his liability upon the note by the neglect of its holder to give him proper notice upon its dishonor, the security held for his indemnity is discharged, and neither the holder nor any other party to the note can claim the benefit of such security by subrogation to his rights. For an endorser does not, by taking indemnity against his endorsement, waive his right to notice, but the holder is entitled to the benefit of any securities received by an insolvent endorser as a surety for prior parties, if all the endorsers of a bill of exchange have become such for the accommodation of the drawer, and he gives deed of trust for the indemnity of the two last endorsers, the first endorser cannot compel them to sell the trust property and apply it to the payment of the bill. He will have no right of subrogation to their security until he pays the bill. 189. Bill drawn against a consignment of merchandise and made a lien upon it. The endorsee of a bill which purports to be drawn against a consignment of merchandise and has annexed to it a warehouse receipt for the merchandise and a certificate by which the drawer declares a lien upon the merchandise in favor of the holder of the bill, reserving to the consignee upon whom the bill is drawn the right to sell the merchandise upon its arrival and hold its proceeds in trust for the holder of the bill, acquires by taking the bill a special property in the merchandise thus appropriated for its payment, and may enforce the trust by a bill in equity against the consignee and one to whom the latter has pledged the property after accepting the bill. The endorsee or transferee of the bill acquires a special property in the goods described in the shipping documents which accompany it, and the shipper is deprived of his property and has no longer either possession or title, and one who pays such a draft at the request of the drawee, and on the latter's agreement that he shall be secured by the property, will acquire the same right to the property. If, however, the acceptor on his acceptance was to acquire against the drawer the full control of the property, or if the property had been delivered to the carrier as agent for the purchaser upon whom the bill was drawn, though the carrier's receipt was annexed to the bill, the case would be different. A Liverpool merchant, wishing to obtain consignments of cotton from a Pernambuco firm, and being called upon for security, obtained from a bank a letter of credit by which the bank authorized the Pernambuco firm to draw upon them for such consignments, and engaged to honor the bills upon receipt of the shipping documents. Some shipping documents were sent, and some bills accepted, and one bill was accepted without any shipping documents being sent. And then, before any of the bills fell due, the bank became bankrupt, and bills arriving immediately afterwards were unaccepted. The agent of the Pernambuco firm claimed to prove against the bank for the full amount of the bills, without bringing into the account the value of the cotton which had been sold or which remained on hand. But it was held that he had no right to do so, that the holders of the unaccepted bills had no lien upon the cotton in the hands of the bank, so as to enable them to treat the bank as their trustee, and the bank was indebted to the holders of the bills only for the surplus remaining after the goods consigned had been applied to the payment of the bills accepted. 189a. Right of endorsee of bill of exchange with fraudulent bill of lading attached. Since the endorsee of a bill of exchange, having a warehouse receipt or bill of lading attached to it, is ordinarily held to acquire no greater right of property in the goods thereby represented than belonged to the original shipper under whom he claims. And since a carrier is not bound by a bill of lading given by his agent for goods which have not been actually delivered to the carrier, so the endorsee of a bill of exchange purporting to be secured by such a bill of lading, though taking it bona fide and in reliance upon the apparent security, cannot, it is generally held, enforce the contract of the bill of lading against the carrier. Nor can the endorsee compel the carrier to answer for a misdescription of the goods in the bill of lading caused by the fraud of the consignor, but it is sometimes considered that the carrier is estopped against such a bona fide endorsee for value, to deny his receipt of the goods stated in the bill of lading. and the general rule of law has in England, and in many of our states, been similarly modified by statutes. But if the goods are actually received by the carrier, though after the bill of lading was given, the rights of such an acceptor or endorsee are valid, unless the goods were so received upon a new agreement wholly independent of the old bill of lading. 190. Securities held by a banker against his acceptances available to their holders. Securities held by a banker against his acceptances are available to the holders of the bills, through the equity of the banker or his assignees in bankruptcy, to have them applied to meet the acceptances. Though it has been said that while the rule is perfectly just where the securities are sufficient to pay the bills in full, yet if the case is otherwise, it gives the bill holders an advantage at the expense of the acceptor to which they are not entitled, and that the reasons assigned for the extension of this rule to the case of a deficient security are unsatisfactory, and appear to overlook the fact that when the whole benefit of such a security is given to the bill holder, the estate of the bankrupt acceptor may lose some part of the indemnity to which he is entitled. On the same principle, the endorser of a bill of exchange has an equitable claim upon property deposited with the drawee as a security against his acceptance thereof upon the latter's bankruptcy. But the application of this principle will not be prevented by the fact that the person who deposited the security was not a party to the bills either as drawer or endorser, provided they were drawn with respect to a transaction in which he was liable. Where merchants consigned goods to one party, and by arrangement drew bills for their value upon another party, who accepted them, it was held, upon the bankruptcy of both, that remittances made by the consignor to the acceptor on account of the bills should be specifically applied to the payment of the bills. Nor is this principle limited to the bankruptcy of the parties to the bills. It will be applied upon their mere insolvency. The acceptor has a lien against his acceptances upon property in his hands belonging to the drawer, and the holder of the bill may claim the benefit of this lien by way of substitution, just as a creditor may hold the indemnity of a surety upon the latter's insolvency. A mortgage given to the acceptor of bills to secure their payment by the drawer will, upon the insolvency of the drawer and the acceptor, be applied directly to the payment of the bills. So, where one who has procured bills to be drawn for his accommodation afterwards gives a deed of trust to the acceptors thereof to secure notes given to the acceptors for the amount of the acceptances, the holders of the bills may resort to the trust property for their payment when dishonored, if the notes have not been negotiated to bona fide holders for a valuable consideration. Were the holders of a judgment given to secure them for their acceptances made for the benefit of the judgment debtor assigned it to a prior creditor of their own, the collection of the judgment by such assignee was restrained on a bill in equity filed by the judgment debtor for whose benefit the acceptances had been made. The holders of the acceptances were declared to have an equitable interest in the judgment, and the proceeds of the judgment were directed to be applied to their payment. 191. This principle extends to all parties to the bill. This substitution to the benefit of security held for the payment of negotiable paper will be made for the benefit of all parties thereto, who, by reason of their liability thereon, have paid the same. One who has accepted a bill of exchange on the agreement that certain property of the drawer in his hands shall be applied to the payment thereof is entitled, upon paying the acceptance out of his own funds, to hold this property for his reimbursement against attaching creditors of the drawer. The payee of a promissory note who has transferred it by endorsement, and has afterwards, on the failure of the maker, been compelled to take it up, may enforce a mortgage given by the maker of the note to the endorsee, while it was held by the latter to secure its payment. If the holder of a promissory note who has proved it against the estate of the first endorser, and has then received payment of it from the second endorser, afterwards obtains a dividend in the bankruptcy proceedings, he must account for this dividend to the second endorser and not to the bankrupt's creditors. If debtors have given acceptances to their creditor for their debt, and have also given to him security for the payment of their indebtedness, and have then gone into bankruptcy, and the holders of the bills have proved them for their full amount under the bankruptcy, the creditor cannot have the full benefit of the security without first himself taking up these bills. The security will be applied first to pay to the creditor any balance due to him over the amount of the bills, and then to relieve him from his liability under the bills. And if the holder of a note surrenders collateral security, which he holds therefore from the maker. This will operate the discharge of the endorser to the extent, but only to the extent, of the real value of such security. The endorser will be discharged under such circumstances just as a surety eo nomine would be. 192. Property and securities deposited by drawer with acceptor. The property and securities deposited by the drawer with the acceptor of bills for their payment remain subject to the trust in the drawer, and so far as not applied for that purpose, they are held by the acceptor for the drawer. G. In Malaga was in the habit of drawing bills on Y. In London, and of remitting bills to the latter to enable him to meet his acceptances. Y. Rendered to G. half-yearly accounts, charging him with bills accepted, and crediting him with bills remitted, with a credit of interest to the same time. If a bill remitted was dishonored, then its amount was entered on the debit side, thus in effect striking it out of the account. Y. Became insolvent, and compounded with his creditors, crediting Y. With the amount he thus paid on his acceptances, the balance of account was in favor of G. At the time of suspending payment, Y. had remittances which has been thus sent to him by G. It was held that as Y. had been discharged from his liability on his acceptances by his composition, and as the remittances were specifically appropriated to the payment of the acceptances, the remainder of the remittances after Y. had been reimbursed for the amount that he paid on the bills belonged to G. But if the remittances, being negotiable paper or current coin, had been passed for value to a bona fide holder, without notice of the equities existing in favor of the drawer could not reclaim them from such a holder. On the same principle, if the acceptor of bills deposits with one banker money and negotiable securities for the express purpose of taking up his acceptances payable at another banker's, and the first banker remits the deposit to the second without notice of the instructions on which it was received, the acceptor cannot follow the property into the hands of the second banker to the prejudice of the latter's rights against the first. 193. Holder not substituted to security held by one under no liability, unless actually appropriated. The holder will not, upon the insolvency or bankruptcy of both drawer and drawee, be substituted to the benefit of security deposited by the drawer with a drawee to secure the latter against his intended acceptances, unless the drawee has accepted the bills, or unless the holder has the right to prove his demand against the estate of both the drawer and the drawee. Nor will such substitution be allowed if the security is held by the acceptor, not specifically against the acceptances, but for the payment of any money which should be due from the drawer to the acceptor, even though there may be no indebtedness apart from the bills. But an actual appropriation to the payment of bills of property consigned by the drawer to the drawee will be upheld, although the latter has not accepted the bills. The consignor of coffee drew bills upon the consignees, which bills were negotiated to the plaintiff. The bills did not purport to be drawn against any particular shipment. The consignee refused to accept the bills, and they were protested. The consignor then wrote to 1S asking him to take charge of the consignment, realize on it, and honor the bills. The day before the maturity of the bills, S. wrote to the plaintiff, saying that he expected soon to receive from the consignees the coffee sent by the drawer against the bills, and would then write the plaintiff again. Soon afterwards S. received the warrants for the coffee from the consignees, and wrote to the plaintiff to that effect, referring to his previous letter, and saying he should dispose of the coffee as instructed by the consignor, and would send further particulars in due time. The same day the consignees attached the coffee as the property of a firm who they alleged had an interest in it, but with whom S. have had no dealings. But it was held, on the plaintiff's bill in equity, that the consignor had given S. authority to make an equitable charge upon the property, and S. had acted on that authority, and that the coffee must be applied to the payment of the bills. 194. Right of holders to securities held by acceptor, not a paramount one. This right of the holders of negotiable paper to be substituted to the benefit of securities for its payment given by one of the debtors upon it to another cannot be preferred to the legal rights of prior creditors of both these debtors in the same transaction. This principle was established in an English case in which it appeared that two separate firms, one in Bombay and one in London, were engaged in the joint adventure of buying and selling goods in England and in India. The Bombay firm drew bills on the London firm, which they discounted in India, and with the proceeds they bought cotton, which they consigned to London, specially to meet these acceptances. Both firms being insolvent, the holders of certain unpaid bills which had been drawn and accepted in this way claimed to have the proceeds of the shipments of cotton appropriated to their payment, and it was held that they were entitled to this appropriation, but that it must be subject to the right of any creditors of the joint adventure to have the cotton applied first to their payment as part of the assets of the joint adventure. And it has been intimated that the rule that securities held by a banker against his acceptances are available to the holders of the bills will not be applied in bankruptcy where the drawers owe the acceptors on other accounts more than the amounts of the bills, at least if the acceptors have a general lien on the securities so deposited with them. If the drawer of bills has made remittances to the acceptor to cover his acceptances, and the acceptor has become insolvent before the payment of the bills, and the drawer has also become insolvent, owing the acceptor on general account a larger sum than the amount of the bills, but has not gone into bankruptcy, the equity of the holders of the bills to be paid out of these remittances will not prevail over the direction of the drawee to have them applied upon his general indebtedness to the acceptor. So where the acceptor of a bill paid the amount thereof to his bankers in order to meet it, but the day before the bill matured died indebted to his bankers on general account, and the bankers dishonored the bill, it was held that the drawer, having taken up the bill, could not compel the bankers to reimburse him, as having received the amount of the bill in trust for its payment. 195. Holders' right to control securities given by drawer to acceptor no greater than drawers. The right of the holders of bills to the benefit of property deposited by the drawer with the acceptor thereof will, even upon the bankruptcy of the acceptor, he limited by the right of the drawer against him. It will not extend to the case of a guarantee given to the acceptor by a third person, no notice having been given by the holder to the guarantor. The claim of the holder of the bill cannot prevail against one who has in good faith, and for value acquired the deposited property from the drawer and the acceptor. If the drawer could not require the appropriation of the property to the payment of the bills, the holder will have no such right. Thus A, in England employed B, in South America to purchase goods for him. The mode adopted was that B raised money by drawing bills on A and selling them, and with the proceeds bought goods, which he shipped to Liverpool, consigned to A. In his accounts B credited A with the bills and charged him with the cost of the goods and with his commissions, and in his letters he directed A to place the price of the goods to his credit and the bills to his debit. Both A and B became bankrupt. When A became bankrupt, goods were in transit to Liverpool, and some of the bills out of the proceeds of which the goods had been bought had been accepted, and others were presented to A after his bankruptcy and were unaccepted. The goods having arrived and come into the possession of A's trustees in bankruptcy, it was held that the holders of the bills had no right to have the goods specifically appropriated to their payment. The property and the goods passed to A, subject only to B, as right of stoppage in transitu. It did not revest in B, upon A's failure to accept some of the bills, and the facts showed no agreement by which B would have a charge on the goods in the hands of A and a right to have them applied to take up the bills. If the property was purchased originally at the joint risk of the drawer and the drawee, although the drawee has promised the drawer to protect the bills, but has afterwards, upon the insolvency of the drawer, refused to accept them, the right of the holders of the bills to the property will be limited to the surplus of its proceeds over the amount due from the drawer to the drawee. Mere direction in a bill of exchange to place the amount to the account of a shipment made by the drawer to the acceptor, or a mere letter of advice accompanying the bill to the effect that the bill is drawn on account of a specified shipment, will not operate a specific appropriation of that shipment to the payment of the bill, which can be enforced against a purchaser of the goods from the acceptor. Just as the mere fact that bills are given in partial payment for property agreed to be sold by the drawer to the acceptor, upon which the seller retains a lien for the unpaid portion of the price, will not, upon the bankruptcy of both parties, give to the persons to whom the bills have been negotiated any lien upon the property for their payment. 196. Holder's right to application of security perishes with that of its depositor. If the drawer of bills holding security from the acceptor for their payment has, by the substitution of new bills therefore, lost the right, as against the acceptor, to have the security applied for their payment, the holder of the old bills, claiming under the drawer, will also be deprived of such right. Thus, a debtor borrowed money from a corporation, giving it high acceptances and depositing shares as security therefor. When the bills became due, the corporation presented to him fresh bills for acceptance, stating them to be in place of those falling due, and he accepted the new bills accordingly. Both he and the corporation then became insolvent. Both sets of bills being still outstanding, it was held that the holders of the first bills had no equity to have them paid out of the shares. For the letter in the debtor's new acceptances had put an end to the security as to the first set of bills. But it is to be observed that the first set of bills did not purport to be drawn against the security. 197. Taking bill on the credit of the funds is not enough. Although the drawer of a bill has funds in the hands of the drawee, and the holder takes it upon the assurance of the drawer that the funds are specifically appropriated to the payment of the bill, this assurance will not of itself operate such an appropriation, unless the bill was so drawn against that particular fund as to constitute an equitable assignment thereof. Otherwise, the mere drawing and negotiation of the bill does not pass any right to the fund. Thus, where the plaintiffs bought a bill of exchange on the assurance of the drawer that there were funds in the hands of the drawee which were specifically appropriated to meet it, but before any acceptance of the bill the drawer stopped payment. Although it was at first considered, upon the plaintiff's bill against both drawer and drawee, that the plaintiffs, having taken the bill upon the faith of these representations, were entitled to be paid its amount out of the funds of the drawer in the hands of the drawee, yet on appeal it was decided that the plaintiffs had no right to any charge upon these funds. Where one bank has deposited bonds with another bank as security against its overdrafts, and has then become insolvent, being indebted to the second bank, the holders of such bills, drawn by the first bank before its insolvency, but presented afterwards, cannot resort to the proceeds of these bonds to the prejudice of the right of the second bank to apply them upon its own demand. 198. Extent of holders' right of substitution to acceptors' securities. The substitution of the holder of a bill to securities held by the acceptor will, if the parties to the bill have not become insolvent, be limited to the rights of the acceptor. If the acceptor's security is a mortgage from the drawer, conditioned only to indemnify him for what money he should actually have paid upon his acceptance, then, as the acceptor could not enforce his security until actual payment by him, the holder of the bill cannot require a foreclosure of the mortgage for its payment. The acceptor holding such indemnity may, before the rights of the creditors arise upon his insolvency, release the whole or part of it to the drawer, and the holder of the bills cannot, upon the acceptor's subsequent insolvency, avoid such release against those who have since acquired rights in the released property. 199. Rights of an acceptor to securities held against the bill by prior parties thereto. The acceptor of a bill, being the party primarily liable upon it, cannot, upon paying it, be subrogated to the benefit of a security given by the drawer to the payee to secure its payment. Thus, where the purchaser of property gave to the vendor a mortgage on the property to secure the payment of a bill drawn by the purchaser in favor of the vendor upon a third person for the price of the property, the mortgage reciting that a lien was retained on the property in favor of the vendor or any other holder of the bill, but not stipulating that the drawee should have the benefit of the mortgage on paying the bill without having been put in funds therefor by the drawer, and without being bound as to the drawer to pay it. If the bill is paid by the drawee at its maturity without any conventional subrogation in his favor at the time of the payment, the debt will be extinguished as to third persons, and the mortgage will be extinguished as to the holders of other liens upon the mortgaged property. For the acceptor was the principal debtor upon the bill, and simply paid his own debt in paying it, and a mortgage, containing no stipulation in his behalf, cannot be kept alive for his benefit, or for the benefit of any other person, unless this results from the terms of the bill itself. An endorser and an accommodation acceptor of a bill are not co-sureties, and the acceptor cannot be subrogated to the benefit of a mortgage given by the drawer to the endorser to indemnify the latter against his liability, even though the bill was paid after being protested by giving to its holder the note of the drawer. with the endorser and the acceptor as sureties thereon. And the acceptor, on paying this note, took an assignment of all the securities in the hands of the endorser and of the holder, because the mortgage was given only for the personal indemnity of the endorser, and not for the payment of the bill, so that the acceptor had no right to it. And on the endorser's being indemnified by the acceptor's payment of the substituted note, the mortgage became functus officio. But in New York, it has been decided that although at law the accommodation acceptor of a bill is regarded in favor of a bona fide holder of the bill as the principal debtor thereon, yet as between the drawer and such acceptor the latter is regarded in equity as merely a surety, and is entitled upon his payment of the bill to be subrogated to the benefit of any securities taken by the holder of the bill from the drawer to secure its payment. And accordingly, in an action against such an acceptor by a non-resident holder of the bill, the drawer having become insolvent, the defendant may, under the code allowing the giving of both legal and equitable relief in the same action, demand such subrogation upon payment of the amount due to the plaintiff. 200. Acceptor's securities to be applied upon all acceptances alike. Security in the hands of an acceptor for the payment of his acceptances will, in case of need, be applied to the payment of all the acceptances alike. If the holders of some of the acceptances have established their right by litigation, they will be preferred only to the extent of a fair share of the expenses of their litigation. Thus, a drawer having given to his acceptor a judgment as security for his acceptances, these acceptances were negotiated, and some of them remained unpaid in the hands of 3 firms. The acceptor assigned a portion of the judgment to 2 of these firms as collateral security for the payment of the drafts which they respectively held. They enforced the judgment at their own expense and claimed to be fully paid out of its proceeds, leaving only a small balance for the benefit of the other firm, which had taken no part in the litigation. But it was held that the security of the judgment attached to all the unpaid acceptances alike, and that the holders were entitled to pro rata shares of the money which had been collected, the litigants receiving in addition to their dividend a fair share of the costs and expenses of their litigation. But the court also said that such third firm would be required to exhaust whatever independent securities they had, and should not be allowed to receive their pro rata share until such other securities had been exhausted or shown to be worthless, and that anything which they might receive from such securities should be reckoned as a part of their dividend, so as to increase the share of the 2 firms which had homed the burden of the litigation and had realized the fund. 200A. Subrogation of holder of check to rights of drawer. By analogy to the now widely adopted rule that one for whose benefit a promise is made, though not a party to the contract or privy to the consideration, may maintain an action thereon, it has been occasionally decided that the holder of a check is subrogated to the rights of its drawer, the depositor, and may sue the bank upon its failure to pay the check in his own name. But the old rule is still generally maintained, that such an action can be brought only by the depositor. But it has been held that a check drawn against the whole of a specific fund deposited in the bank in the name of the drawer, but belonging in equity to the payee, transfers to the payee on its delivery to him the legal title to the deposit, and that when this payee, in pursuance of his prior parole assignment of the fund made for value, endorses and delivers the check to his assignee, the title to the deposit vests in that assignee, even against subsequently attaching creditors of the depositor, though an ordinary check cannot be treated as an equitable assignment of the money for which it calls, and would not, before its payment or acceptance or certification by the bank, give the payee any rights against a creditor of the depositor making an intervening attachment. 201. Whether suits or judgments extinguished upon payments by parties secondarily liable. If separate suits have been brought against the maker and the endorser of a promissory note, and the endorser pays the amount due with the agreement that the suit against the maker shall be prosecuted for his benefit, the maker cannot avail himself of the endorser's payment as a defense to the further prosecution of the suit against himself. Nor, if the endorser's payment was made after judgment against the maker, can the maker's bail set up such a defense in an action upon their recognizance. If separate judgments have been obtained against maker and endorser, the latter may pay the judgment against himself, and take an assignment of that against the maker and enforce it for his own benefit. If the maker and the endorser have been jointly sued under the New York statute, and a judgment has been recovered against them, The endorser, upon paying the judgment, may take an assignment thereof from the creditor and use it for his indemnification as a subsisting judgment against the maker. If an endorser of a bill of exchange has recovered a judgment thereon against the maker, this judgment will not be extinguished by its assignment to a prior endorser of the bill upon the latter's paying the amount due thereon. The endorser may be subrogated to the benefit of a judgment against the maker without taking an assignment thereon, but this subrogation of the endorser is to a suit or a judgment against the maker directly upon the original obligation. It does not extend to the prosecution of a merely incidental remedy, such as an action against a notary for negligence in making a protest of the note, whereby other parties were released. The payment of a note by one of several joint promisors extinguishes it, and it cannot afterwards be kept alive against the other signers, nor will either the maker or a surety for the maker acquire, by paying a judgment on the note, any right of action against the endorser.